I'd like to discuss tips on effective legal writing. Number one, keep it simple and clear. Follow the rule of 5 and 10. If it's a simple matter, make sure your motion is less than 5 pages long and your argument is less than 5 minutes long. If it's more complex, make sure your argument's less than 10 pages long and your argument's less than 10 pages long. Know what the judge likes and doesn't like. Again, consult with your colleagues and friends as to what the judge likes or doesn't like. Don't repeat things you've said in your other motions unless they're relevant to this motion. In bankruptcy, we see motions that the first 4 or 5 pages are exactly the same in every motion. I suggest the very first sentence in those sections should be, please do not read the next 4 or 5 pages since they're repetitive. Put it in bold so we know we don't have to read it again. At the end of those 4 or 5 pages, but now you can start reading the argument because this is what really matters. Now I'm being facetious, but that's what judges see or think when they see these repetitive motions over and over and over. Make sure your introductory paragraph is request the specific relief you are seeking, and make sure your prayer for relief contains the specific relief you're seeking. A general request for relief often will bite you in the butt. And the reason is, when you're there, you may ask for X, but you haven't asked for it in the prayer for relief nor the introductory paragraph. The judge technically should not grant any relief that is not contained in your prayer for relief. This is obvious, but avoid typos and incomplete sentences. If you haven't read the motion 3 times after you've completed it, you're making a mistake. If you have a cooperative relationship with someone else in your firm or a coworker, make sure they read your longer memos for comments. Avoid typos and incomplete sentences. If you haven't read the motion 3 times after you've completed it, you're making a mistake. If you have a cooperative relationship with a coworker, have them read your longer memos for comments. Typos really create a poor impression of you, and you will lose credibility with the judge. Avoid string cites. Cite a few cases that support your position and distinguish the opposing party's cases. By the way, remember, you have an ethical duty to cite any law that is counter to your position, although you're entitled to distinguish those cases either factually or legally. Recite key facts. Attach portions of any key documents, but don't overdo it. Do not use derogatory language concerning your opponent. This just merely turns a judge off. Remember, judges are busy and have a lot of cases. The easier you make it for them, the more likely you'll be successful. I might add that many state court judges would appreciate if key cases are attached. Ask a judicial assistant if they would. Finally, make sure you check the local rules for font size, spacing, number of pages, and formatting. The local rules will also require any requirements for conferring with opposing counsel before you file a motion. Make sure you include it. Please see Judge Mike Williamson's Practical Evidence Manual, which is linked on our website and on the Middle District of Florida's Bankruptcy Court's website. It has very practical and helpful information for you.